$550 million, right? Just imagine this scenario for a sec. You're a corporate legal executive, and your company files a routine, albeit high-stakes, lawsuit in a U.S. court to protect a highly profitable piece of intellectual property. You think you're playing offense, obviously, but instead, that exact same lawsuit accidentally triggers a $500 million regulatory nightmare on the total opposite side of the globe. It honestly sounds like the plot of a corporate thriller, but for one major financial firm, it became a very harsh reality.
Welcome to This Explainer. Today, we're unpacking the current state of trade secret litigation, and we're tailoring this specifically for you, the corporate legal executive. You're navigating this rapidly shifting environment in 2024, where the very act of defending your company's proprietary data can sometimes invite totally unprecedented risks. We're going to look at the macro data, the shifting legal standards, and quite frankly, one of the most fascinating cautionary tales in recent memory.
Okay, let's look at our agenda. We'll be covering 1. The rising litigation landscape. 2. The danger of vague secrets. 3. The Jane Street disaster. 4. Regulatory fallout in India. 5. New regulatory headwinds. And finally, 6. Key takeaways for executives. Let's get right into it. Section 1. The rising litigation landscape.
So for legal executives, understanding the sheer volume of this litigation is step 1 in managing enterprise risk. The post-DTSA era, meaning after the Defend Trade Secrets Act of 2016, allowed parties to sue in federal court, has seen a massive surge in federal trade secret cases. After a tiny dip during the pandemic, the numbers are climbing right back up, projecting over 1,300 cases this year alone. If you're managing a legal budget, you know for sure that this kind of volume means trade secret litigation is absolutely no longer an edge case. It's a central pillar of corporate dispute resolution.
And here's something super interesting. These trade secret claims, they almost never travel alone. When a company alleges trade secret theft, they most frequently pair it with breach of contract allegations. We're talking employment agreements, non-disclosure agreements, or vendor partnership contracts. This basically tells us that your very first line of defense is always going to be the strength of your corporate contracts. Now, we also have to talk about the financial stakes, because they're absolutely massive. In January of 2024, materials solutions provider Trinseo was awarded a $71.2 million damage award. Yeah, you heard that right. This was for the theft of trade secrets related to their polycarbonate manufacturing, so specifically things like process flow diagrams, design drawings of manufacturing plants, and equipment specifications. And just to really drive the point home, here's another staggering number: $81 million. That's the jury award handed down recently to an electric aircraft startup called Zunum Aero against aerospace giant Boeing. Boeing was accused of misappropriating trade secrets related to hybrid electric and all-electric aircraft tech. When the IP is highly technical and central to a company's future, juries are clearly showing us they aren't afraid to award tens of millions in damages. Section 2. The danger of vague secrets. Now, getting those massive awards is incredibly difficult. Courts are demanding extreme precision. You literally cannot just throw everything at the wall and see what sticks. In the Zunum case, they initially handed a 550-page compilation of alleged secrets to the judge, which the court deemed way too voluminous and actually had to draft its own categorical definitions. But contrast that with a company called Alifax, who went the exact opposite route. They were far too vague in describing the software process for their signal acquisition technology. Just to understand the severity of that mistake, listen to this quote from the Federal Circuit Court of Appeals regarding Alifax. They ruled that Alifax failed to describe the alleged signal acquisition trade secret with sufficient detail. Ouch. This really drives home the strict legal standard here. Failing to properly define your secrets makes it impossible to win your case. Because Alifax couldn't clearly define the scope, the court actually struck that claim entirely from the jury verdict form. You absolutely must know exactly what your secrets are before you even step foot in a courtroom. Section 3. The Jane Street disaster. Let's look at this whole thing strictly through the lens of unintended consequences. This really built into an explosive escalation in April 2024. Jane Street, which is a massive quantitative proprietary trading firm, sued Millennium Management to protect an option strategy that netted them over $1 billion in 2023. They claimed 2 former traders took it to Millennium. But here is the critical failure. During the legal proceedings, lawyers accidentally disclosed in court that this secret strategy was being deployed in Indian markets. That one little slip-up drew the attention of the Securities and Exchange Board of India, or SEBI. By July 2025, SEBI had launched a massive investigation, resulting in a $550 million escrow order against Jane Street. Section 4. Regulatory fallout in India. So how exactly does a company go from being the plaintiff in New York to the target of a massive regulatory action in Mumbai. Well, once SEBI knew Jane Street was operating a billion-dollar secret strategy in their markets, they started investigating the firm's trading logs. SEBI's 105-page interim order actually accused Jane Street of using a strategy defined as extended marking the close. Basically, SEBI alleged this algorithmic trading strategy distorted index levels in the Bank Nifty specifically to benefit Jane Street's massive options positions at the end of expiry days, which allegedly caused losses to retail investors on the other side. Talk about the ultimate legal boomerang. Jane Street's initial intent was just a civil complaint designed to protect a highly profitable $1 billion proprietary option strategy from a competitor. They viewed themselves as the victim of IP theft. But the resulting SEBI enforcement action brought accusations of market manipulation, trading bans, and an order to deposit over $550 million in alleged unlawful gains into an escrow account, which, by the way, they did comply with while reserving their rights to challenge it. It's just a staggering demonstration that aggressively enforcing your IP can accidentally expose your core business practices to devastating regulatory scrutiny.
Section 5. New regulatory headwinds.
Now, let's transition back to the macro environment. The Jane Street case highlights the dangers abroad, but for corporate legal executives, there are major domestic shifts happening right now, too. I want to quickly brief you on two massive headwinds that will completely alter your litigation strategy in 2024 and beyond. First, the FTC announced a rule aiming to ban most post-employment non-compete clauses, slated to start in September 2024. If you can no longer stop employees from leaving for competitors, relying on trade secret law is going to become your primary weapon for protecting corporate data. Second, the Northern District of California introduced a whistleblower pilot program offering non-prosecution agreements for individuals who report IP theft and corporate crimes. This means your internal compliance and reporting cultures are more critical than ever, simply because the government is actively incentivizing your employees to bypass you and go straight to the authorities.
Section 6. Key takeaways for executives.
Okay, what do we actually do with all this information? Let's conclude this explainer by delivering the actionable, bottom-line synthesis you can take straight back to your boardroom. Based on the WilmerHale data, here are the exact practice tips you should be implementing. Step 1. Adopt regular IP audits to ensure accurate protection. As we saw with Alifax and Zunum, you have to clearly define your assets before stepping into a courtroom. You need to know exactly what is a trade secret, where it's housed, and how it's protected. Step 2. Encourage a strong internal reporting and whistleblower culture. With these new regulatory incentives out there, employees must feel empowered to report issues internally on a timely basis, without fear of retaliation, and trust that corrective action will absolutely be taken. I want to leave you with this provocative final thought. Is your trade secret enforcement strategy creating more risk than reward? The Jane Street saga proves that sometimes opening the door to the courtroom accidentally opens the door to regulators. As a corporate legal executive, balancing the need to aggressively protect your intellectual property against the operational and regulatory risks of exposing your business practices is literally the ultimate tightrope walk of 2024. Thank you so much for joining me for this explainer, and I hope this leaves you looking at your own litigation strategy in a whole new light.